Hi guys, in today's class we are going to discuss class action. So let's start by giving a definition of class action, which is a lawsuit brought by a representative member of a large group of persons on behalf of the members of the group. So there are four requirements for a class action. The first one is numerosity. So 40 is the benchmark, even though in some situation they have certified class actions with less than 40 members, let's say 25. So there is a gray area between 25 and 40, but over 40 there should be numerosity. Number two, the class action has to have commonality, which means that the questions of law or fact are common to the class. So common questions of law or fact. Number three, typicality, which means that the representative has typical claims to those of the class members. So claims or defenses of the representatives parties must be typical to the class members. And number four, the adequacy requirement. This was discussed many times by the Supreme Court, and basically means that the representatives will fairly and adequately protect the interest of the class. So now let's discuss the categories of class actions. The class actions need to fall under one of the following three categories. Number one, anti-prejudice class action, which is a class action designed to avoid the prejudice to the class members or to the party opposing the class. There are some situations where this might happen, for example, inconsistent adjudications. So there is a risk of inconsistent adjudications. Another kind of class action is injunctive and declaratory relief class action. In this situation, the goal is to change the behavior by an injunctive or declaratory relief, not to provide compensation. Here, the most famous example is Brown versus Board of Education. Finally, there is a third type of class action, which is damage class action. In this case, all members claim that they have been damaged by the defendant by the same conduct in the same way, and they are entitled to monetary relief. Now let's discuss notice. All the members of the class need to be given notice under the damage class action, while in the other cases it's discretionary. But in the damage class action, the court has to give the best notice practicable under the circumstances, which may include also individual notice to all the members can be identified through a reasonable effort. Let's move on now to certification. The class action has to be certified by the court, which means that the court will take a look at all the requirements that we discussed before. So numerosity, commonality, typicality, adequacy. We'll take a look at whether the class action falls under one of the three categories, and will provide for appropriate notice under the circumstances. Now let's move on to jurisdiction. Typically, jurisdiction had to be asserted in the following way. For personal jurisdiction, you need only the defendant. For subject matter jurisdiction, there might be federal question, and generally federal question for class action is present in cases of antitrust, securities, civil rights, copyright, or patent law. But there might be also diversity, and in diversity you need only to take a look at the representative, both for complete diversity. So only take a look at the representative if the representative is coming from a different state from the defendant. And the amount in controversy, you need to take a look again just at the class representative. If that claim exceeds $75,000, you have the amount in controversy. Otherwise, there's no diversity. But recently, they've adopted the Class Action Fairness Act. There are some differences in terms of jurisdiction. In fact, here you have minimal diversity, which means that any member has to be diverse from any defendant. If there is this minimal diversity, then you have jurisdiction, as long as there is also an amount in controversy which exceeds 5 million in the aggregate, which means that all the claims of all the class members, not just the representative, like in the original jurisdiction. Finally, let's discuss the settlement. So for a settlement to be approved, you need a court approval. And the court approval comes after a fairness hearing, where the parties discuss whether the settlement is appropriate or not. Of course, all this protection in terms of settlement approval have been adopted to protect the class members. And finally, you have to give notice and an opportunity to opt out. So a second opportunity to opt out has to be given in this situation, because of course if one of the class member thinks that the settlement is not convenient, then that party has to be given the opportunity to opt out. And finally, let's discuss the attorney's fees that are fixed by court. So there is a separate motion that is required for the court's approval of the attorney's fees that are generally a percentage of the recovery. Thank you for watching. Don't forget to subscribe and watch my other videos on civil procedure. Bye everyone.